My name is Jude Anthony Anrelaki Paul and my metric number is 280.50. I will start this presentation by explaining regarding the facts about the case which my group have chose. Before going to discussion about the case, we should know about two important persons who plays major role in a case: plaintiff and defendant. Plaintiff is the one who brings a legal case against the defendant in the court. Meanwhile, defendant is a person or a company against whom a claim or charge is brought in the court. The defendant has to defend their innocence or reputation by defending a case which filed against the defendant by the plaintiff. That's a simple explanation regarding the definitions of plaintiff and defendant. Now let us start to discuss about this case. The plaintiff was a farmer from the village of Kampung Chekli in Kota Baru, Kelantan. The name of the plaintiff is Sheikh Jafar bin Sheikh Ibrahim. He started a part-time business in 1990 by making the appropriate travel arrangements for 12 people from his village and the surrounding area who wanted to conduct the Umrah and Haji in Mecca. The defendant in this case is a travel agency based in Kuala Lumpur that handles travel to various destinations, including Jeddah during the Umrah and Haji seasons. The name of the travel agency is Maju Meha Singh Travel and Tours Sendirian Berhad. According to the plaintiff, in December 1991, he had a meeting with the managing director of the defendant, referred to as DW1, where they reached an oral agreement. The plaintiff managed to gather 151 passengers who planned to perform the Hajj in May 1992. The plaintiff has collected a total of 830,500 ringgit from the passengers, which he paid to the defendant. Once the payment was made, DW1 informed the plaintiff that the passengers would depart in two groups from Subang International Airport. The first group of 74 passengers was scheduled to leave on May 11, 1992, and the second group of 72 passengers was scheduled to depart on May 18, 1992. To prepare for the departure of the passengers, the plaintiff made arrangements for their travel from Kelantan to Kuala Lumpur and purchased return air tickets amounting to 27,180 ringgit. However, on May 11, 1992, the defendant informed the plaintiff that they were unable to obtain visas for the passengers, resulting in the cancellation of the scheduled flight. The defendant assured the plaintiff that the first group of passengers could depart on May 18, 1992, along with the second group, as they would have obtained all the necessary visas by then. As a result, the plaintiff had to make additional arrangements for accommodation and food for the stranded passengers in Kuala Lumpur. On May 18, 1992, when the second group arrived from Kota Baru to Kuala Lumpur, the defendant informed the plaintiff once again that they could not obtain the visas for the passengers, leading to the cancellation of the scheduled flight. Consequently, the plaintiff had to arrange accommodation and food for the second group as well. Finally, on June 5, 1992, all the passengers returned to Kota Baru. The plaintiff is now claiming against the defendant for the cost of the Haji tickets, the cost of bringing the passengers from Kota Baru to Kuala Lumpur, and the expenses incurred for accommodation and food in Kuala Lumpur during the period from May 11, 1992 to June 5, 1992. Now we will move on to the issues of the case. The major issue of this case is based on the question: was there any agreement signed between the plaintiff and defendant? Based on the recommendations by Gurbach, the plaintiff claimed that on 5 December 1991, the plaintiff along with Noriza binti Hassan, the PW3 of this case, arrived at Kuala Lumpur to meet PW1. PW3 confirmed this in evidence. At that time, the plaintiff stated that he had already gathered 100 persons from various villages in Kota Baru who wanted to perform the Hajj in May 1992. He had also collected some amount from them and their passports for purpose of the travel arrangements. In addition, the plaintiff claimed that DW1 verbally agreed that in exchange for the defendant receiving the passengers from the plaintiff and paying 5,500 ringgit per person, the defendant would arrange air tickets for the Hajj to Jeddah for the passengers, apply and secure the visas for the passengers, make plans for the passengers lodging in Jeddah, and pay the plaintiff a commission of 200 ringgit for each passenger he brings for the defendant. The plaintiff claimed that DW1 agreed to the sum of 5,500 ringgit per person, as this was the amount the plaintiff had collected in 1990 and 1991. The plaintiff further asserted that the aforementioned arrangements were always made in order for the passengers to conduct the Haji in May 1992. Additionally, DW1 had said that he was a registered agent who could make these arrangements on the plaintiff's behalf. The plaintiff claimed that DW1 accepted the terms and that the plaintiff promptly gave the defendant the money she had collected from the 100 people as well as their passports. The defendant, on the other hand, denies that there was such an agreement between the plaintiff and defendant. Based on the findings of the court accepts his evidence that there was such an agreement. The plaintiff is a simple villager who makes commission out of the Haji Umrah travel. All the ingredients necessary to constitute an oral agreement exist in this case. The defendant's contention that such an agreement ought to have reduced to writing seems to ignore the existence of oral contracts. The court finds that both the plaintiff and the defendant intended to create a binding contract.
Hi, my name is Asiana Pupa-Amin, matric number 277-883, and I will continue on presenting about holding the case. This case is between Sheikh Jafar bin Sheikh Ibrahim versus Maju Mehar Singh Travel and Tours in Berhad. So, first is the court accepted the plaintiff evidence that there was an agreement between the plaintiff and the defendant. The plaintiff was a simple villager band on making a commission out of this Haji Umrah travel. All the ingredients necessary to constitute an oral agreement existed in this case. The defendant contentions that such an agreement ought to have been reduced in writing seems to ignore the existence of oral contract. The court found that both the plaintiff and defendant intend to create a binding contract. Number two was inconceivable to image that the plaintiff wills collecting a sum of 5,500 ringgit would split the sum, maintain a account, and go through the orders of applying for individuals visas for 151 passengers when he could have easily gone to any other ticketing agent and obtained such a service. Besides, the plaintiff being a simple villagers intending only on making a commissions of 200 ringgit on each passenger would not be expected to provide a cumbersome service of applying for visas. So therefore, the court rejected the defendant contention that it was the plaintiff who applied for the visas and that the defendant had nothing to do with the visas application. So number three, there was no evidence that the passengers had not been refunded their money nor been punished tickets subsequently. There was also no evidence that the passengers have authorized the plaintiff to sue on their behalf or that the plaintiff was suing on a representative capacity. In the circumstance that the court was constrained to hold against the plaintiff for having failed to satisfy the court to claim the sum of 640,500 ringgit. Number four, there was no evidence from the plaintiff that he did not collect the sum of 27,180 ringgit with 151 passengers and that he had on his own paid this sum and was seeking recovery. In the absence of such evidence and considering the fact that the plaintiff was only looking to 200 ringgit commission, it seems unlikely that he had made the upfront payment. In the circumstances, the plaintiff had failed to prove this item of the damage. Number five, it shows cash payment received from various hotels and restaurants. There was nothing on the receipt to link the payment to the plaintiff, nor to this case. This is the tried law that special damage must both specifically plead and prove. In the circumstances, the plaintiff had also failed to prove this claim. Lastly, the agency needs to pay refund to the defendant, who is Sheikh Jafar bin Sheikh Ibrahim.
Hi, good day everyone. My name is Priyanka Devi Paniselvam. I will present the rationale of the holding for this case. Firstly, we will see what is rationale of holding. The term rationale of holding refers to a reasoning and justification behind court's decision or ruling in a case. It is essentially the explanation for the court's holding or the rule of law that the court applied to the case. The rationale may include various legal principles, precedents, or policy consideration that influence the court's decision. So, understanding the rationale of holding is important for understanding the legal reasoning and principle that underlie a particular decision, as well as for prediction how similar cases may be decided in the future. So let's see the evidence. The rule of law that is used in this case is the principle of contract law. That is, a binding contract requires an offer, acceptance, consideration, and intention to create a legal relations. So in this case, the relation of holding is the plaintiff failed to prove his case on a balance of probabilities. The court found no binding contract between the parties because the plaintiff failed to prove that the defendant had accepted his offer to bring the passengers to Kuala Lumpur. The court also found that the plaintiff failed to satisfy the court to claim the sum of Rm 614,500 because there is no evidence that the passengers have not been refunded their money or furnished a ticket subsequently. And there is no evidence the plaintiff was suing in a representative capacity. However, the defendant's counterclaim for the defamation also dismissed because there were no details or particular providing. Therefore, the court held against the plaintiff and dismissed his claim for the sum of Rm 614,500. In conclusion, the case of Sheikh Jafar bin Sheikh Ibrahim vs. Maju Mahal Singh Travel and Tours in Berhad is about a contract dispute between a farmer from Kota Baru and travel agent in Kuala Lumpur. Because of insufficient evidence, the court held against the plaintiff and rejected his claim for Rm 14,500. However, the defendant's counterclaim for defamation also dismissed. Even though our contract laws say that an oral promise made by one party and accepted by other party can be basic of a legal contract, it is hard to show the term of the contract when the parties disagree about what the contract says, a dispute between them. Therefore, this case suggested setting up a written contract, which is an official document with terms and conditions that have been agreed upon and signed by both parties instead of an open contract or oral contract to avoid dispute between them.